Good morning, everybody. I think numbers are still rising on this seminar, but I think we'll make a start. Thank you very much for joining us. Those of you who don't know me, I'm Lesley Anderson. I'm head of the business and property team at King's Chambers. I'm also a member of Gatehouse in London. I want to introduce to you Ben Harding. Again, a lot of you will already know Ben, but was called in 2005, has been a member at King's Chambers since 2008. And he specialises, as indeed I do, broadly in commercial dispute resolution, sometimes at the chancery end of that spectrum. Ben has been described in Chambers UK as a star junior, and I can testify to that because he's acted as my junior on a couple of cases. But enough of the embarrassing fluff. First of all, you're here to join our seminar, which is to look at the recent changes in the disclosure pilot reforms. I'm then going to look at the recent changes to witness statements in Practice Direction 57AC. So that you know, this is being recorded and a recording will be available for you if I can't imagine you'll all want to watch it again, but if you do want to check anything, then please do. We're hoping to finish within an hour. As you probably know from vast experience of doing these things remotely, there is a Q&A function on Zoom, which we would invite you to use. Because we're trying to cover quite a lot of ground this morning, it's possible that we won't get to Q&As in a formal sense at the end of the seminar, although we will plainly try to cover the ground. But if you do have a question, then we'll try and pick it up and deal with it. Thank you very much. At that, I'm going to hand over to Ben.
Thank you, Lesley. Good morning, everybody. This morning, I'm going to talk about where we are following the changes that were made in April 2021 to the disclosure pilot, and where we're going, because there's a further round of changes, or what might properly be called reforms, I think, which are about to come into effect on a date to be confirmed. And I'm going to use some slides to take you through all of that. And I'm going to start, therefore, by screen sharing the presentation, which hopefully should leave you all seeing the slides, but also still seeing Lesley and myself on the side of your screen. So let me just do that to get started. Okay, I hope you should all now be able to see the slides. If there are any issues, don't worry, because my intention is to circulate the slides after the seminar, so that whether by viewing the video or by looking at the slides circulated later, you should be able to see what I've been referring to. As Lesley says, there's quite a lot of ground to cover. So some aspects of this I'm going to go through at a bit of a canter. So I'm not going to go back to the basics of the concepts in the disclosure pilot and how it was originally set up. I'm going to assume that all of us have had the pleasure of having to deal with it to some extent or another in the cases that we've been dealing with since January 2019. I'm also going to deal relatively briefly with some aspects of the changes in April 2021, because I want to probably focus mostly on the more recent changes, which will be new, I think, to some of us. Right, so by way of very brief recap, because I think it's important to bear in mind how we got to this place and to the latest round of reforms. The original point of the pilot was to effect a culture change, and the Chancellor, Geoffrey Voss, as he was at the time, was explicit about that in the UTB LLC and Sheffield United case, which many of you will know. He said in terms that the pilot's intended to effect a culture change. The pilot's not simply a rewrite of CPR Part 31. It operates along different lines driven by reasonableness and proportionality. Now, you might think, well, the parties were always obliged to some extent to use reasonableness and proportionality, but the core of the problem was that although a lot of the tools were there in Part 31, people weren't really using them, and you, in many cases, had standard disclosure by default. And the problem with that, which leads to the second point, is that that probably wasn't fit for purpose in the more modern context, in a world where the vast majority of documents would either be created electronically or stored electronically. So another part of the purpose of the pilot was to introduce us all to a lot of concepts about how to search electronically stored documentation and technology-assisted review and matters like that. And the point of all of that was to ultimately to try to reduce the cost of the process, the overall cost of the proceedings, and to control waste, to control unnecessary disclosure, and to try to remove the spectre, which I think we've probably all seen, of the trial bundle, which contains 1,000, 2,000 pages of stuff which nobody actually looks at. So that was what went into the pilot originally. And it ran for a year or so before the first round of changes was promulgated. Now, one of the features of the pilot is that it's supposed to be a living pilot, so described, presumably as opposed to a zombie pilot or a dead pilot of some kind. And to that end, what was done was to appoint an official monitor of the pilot, Professor Rachel Mulherin of Queen Mary University, who has done a lot of work around gathering feedback from the legal marketplace, from court users and from others, and then making reports on how people have found it in implementation and practice, and then proposing changes which would feed into the work of the disclosure working group, who would then be tasked with producing amendments to it. So the first round of changes were originally circulated in around September 2020 and took effect earlier this year with effect from the 6th of April 2021. Now, speaking for myself, I think you could be forgiven for not even really having noticed that these changes had come in, because they were by and large quite minor in effect. They were to some extent just clarifications of points in the existing pilot, just to make sure that the intention of the people that had prepared it were carried through, and then a few other matters of tidying up inconsistencies and such like. In overview, what I'd say is if you had continued after the 6th of April 2021 doing what you were doing before, you probably wouldn't have been going far wrong. The changes wouldn't have made a great deal of difference to what you were trying to do. The changes certainly didn't have a significant impact, in my own view, on the core concepts in the disclosure pilot or the core stages that you're supposed to go through, and it certainly wasn't anything like a rewrite. But I've summarized there the areas where the changes were made, and I do just want to touch on each of those briefly, because as matters stand, the changes made in April 2021 are still the position that we're working with, because the changes that are now being proposed haven't come in yet. So strictly speaking, they have no status, and what we're working with is the April 2021 position. So, preservation of documents. This was a minor clarification to reduce the scope of the notification that you had to give to employees and former employees. So this had caused a bit of difficulty because it arose from the duty to preserve documents, which required you to send a notice to all relevant employees and former employees to tell them to preserve documents they might have. This was narrowed down to only having to do that where there were reasonable grounds for believing that the employee or former employee may be in possession of disclosable documents, not also in the other party's possession. That was very sensible and I think a welcome change. On the question of known adverse documents, there was a need to clarify the timing, because on the one hand, you had a disclosure duty to disclose known adverse documents once proceedings are commenced by you or against you. And that could have been read as saying that once proceedings are issued, you immediately have to cough up your known adverse documents, which isn't certainly the way things were done before, and wouldn't be a very helpful thing to have to do, to immediately give up the documents that help the other side or shoot holes in your own case. So there was some clarification introduced to make it clear, first, that you don't have to give known adverse documents with your initial disclosure, and indeed you don't have to do it until either the time when you're giving extended disclosure, if that's been ordered, or 60 days from the first CCMC, if in your case there is no extended disclosure ordered, in broad terms. That was, I think, a very helpful development, because I think the question of known adverse documents conceptually was one of the things that people were having to grapple with when the pilot first came in. I've included here reference to an interesting authority I came across Castle Water and Thames Water Utilities, which is a High Court decision of Mr. Justice Stuart Smith. And in this case, the judge decided that although you don't have to search for known adverse documents in their own right, although you may have to do searches, of course, if extended disclosure with a search-based model is ordered, he did find that parties do have a duty to carry out reasonable and proportionate checks for adverse documents. And then if you discover that you have known adverse documents, you must undertake reasonable and proportionate steps to locate them. Now, this to me comes as something of a surprise, because it's not what the pilot says, and there's nothing in the pilot that I think implies that you have to do this. And the reasoning that the judge used to get there, I didn't find particularly persuasive. It seemed to be based on reading back from some passing reference to having to check the position about known adverse documents with people in the organization, if you're a company that would know about those things. So it seems to be quite a step away from what the pilot actually says. And I also think it potentially introduces some difficulties in practice and implementation. So how do you draw the line between a reasonable and proportionate check and a search for documents? How do you determine whether or not you've done what on this authority you're obliged to do? And again, how do you determine what reasonable and proportionate checks are for different types of client? So it's one thing if you're talking about an individual or a small company with a director who knows everything about what's going on. But what if you're dealing with a client who is an insolvency office holder who has very limited knowledge about the company? How do you test what reasonable and proportionate checks are there? Anyway, I don't want to dwell on that, but I came across that and thought it was interesting and something to be aware of, and potentially to have to advise clients about in terms of those initial stages where you're advising them about their disclosure duties and what those require. There were some relatively modest changes around the subject of the disclosure review document and the list of issues for the list of documents, which are, I think, the areas which are probably for many people the real bugbear about the disclosure pilot, and where a lot of the disagreements do seem to feature. So in relation to the disclosure review document, there was some clarification that you don't have to fill in all parts of it, and that you don't have to do a list of issues for disclosure in the whole of the section 2 with all the detail about where documents are stored and electronic review, etc., unless there's search-based disclosure being sought. This was all helpful and sensible, I think. Some of it was already there, but hidden away in the explanatory notes to the DRD, but moved up into the pilot. Then finally, in terms of the April 2021 changes, there were some modifications around disclosure guidance hearings and Model C. And I'll be coming back to disclosure guidance hearings in a bit more details, because this is one of the areas where the current raft of changes is quite significant. What had originally been the position with disclosure guidance hearings was that they were supposed to be about the scope of extended disclosure or the implementation of an order for extended disclosure. Those were the things about which you could seek guidance. And the circumstances in which you were entitled to seek a disclosure guidance hearing was when the position was, and you were prepared to certify that, the absence of guidance was going to affect the court's ability to have an effective CCMC, or was going to affect the party's ability to carry out case management directions effectively. So it was quite narrow in terms of when it was appropriate to seek a disclosure guidance hearing, and also in terms of what the guidance was supposed to relate to. And certainly in my own experience and my own practice, they have been few and far between. I think I can say that there have been 2 or 3 cases where a disclosure guidance hearing has been sought, and none of them have as yet taken place. And at this point, I'd be interested to know what the experience in the virtual room has been about that. So I'd invite you, just out of interest for me, certainly, to perhaps use the raise hands feature, just to give an indication to us of how many of you have actually had an effective disclosure guidance hearing happen. And I might need to come off the screen share to see. Okay, that's interesting. I think that's not entirely different to what I was expecting. So clearly, a number of you have had them, but by reference to the total number of people that there are on the call, it doesn't seem to be all of that many. Okay, thank you for that. I will resume the screen share. Now, this was an area that needed a bit of further work, therefore, in the modifications, and many of you will be aware of the decision of Joanna Smith QC, sitting as a Deputy High Court Judge in the Vanning Capital case, where she'd had a hotly fought application under paragraphs 17 and 18 of the disclosure pilot in front of her. So in effect, the disclosure pilot equivalent of specific disclosure applications. And she started her judgment with quite a stern comment that really the parties should have tried to use the disclosure guidance hearing process to try and resolve the issues between them, but nobody had even tried. All that said, there was no particular sanction imposed at that point. The judgment doesn't record what happened on costs, so it may well be that when it came to costs arguments, the judge had something to say about that. But there are some other authorities along these lines as well, and I think there is a bit of a drive both from within the pilot and from the bench to try to get people to make use of this process. And I can see a time where there probably will be cost consequences if you end up with a contested disclosure application on a point which the court thinks you really could have got disclosure guidance about. Finally, on the April 2021 changes, there was quite a lot of additional explanation and guidance in the explanatory notes about Model C, which is one of the parts of the process which certainly in my own experience has been proving most contentious and most likely to result in issues still needing to be decided at the case management conference, because you'll have differences in approach about what the issues for disclosure are and then what the requests within the issues for disclosure should be. And the issue that was arising was that people were using Model C to ask for any and all documents relating to a particular thing or time or event. And the guidance that was added in April 2021 was intended to make it clear that Model C, if you're going to use it, has to be narrow and focused, and it's not to be used like Redfern schedules in arbitrations, where you end up with a very long list of requests for documents or all and any documents relating to just about every issue that might potentially come up in the arbitration. So that's specifically mentioned as something that the process is really not for. And I think there are signs that that has started to bed in. Anyway, those changes took effect from 6th of April 2021, and people had some advance notice of it because they were introduced originally, I think, late in 2020. Now, there is further reform, I would call it now, because I think the current round of changes is more substantial in effect and scope. So in July 2021, there was published an announcement on the judiciary.uk website, and you can find it if you just search for disclosure pilot judiciary.uk. The link will also be in the slides when they go out. And this did a number of things. The first is to announce that the pilot was going to be extended again, so that it will run till the end of December 2022. So it will have been in place for a total of 4 years by then. And it also introduced a range of reforms dealing with the particular points that I've set out there: multi-party cases, various changes around initial disclosure, issues for disclosure, Model C and D, important changes to disclosure guidance, as it is now called, and a potential path for less complex claims through the pilot. Now, in terms of the status of all of this, according to the announcement, the amended versions of the pilot and the explanatory notes were considered by the Civil Procedure Rules Committee back on the 9th of July 2021 and approved in principle, but sent away for a bit more amendment work to be done by the Disclosure Working Group. That work has apparently been done. And so when you go to the website with the announcement, you can find there versions of the proposed amended disclosure pilot, which take account of the further work that the disclosure working group was supposed to do. And there is both a clean version and a red line version if you want to see the changes from what you're used to. For my part, I'd suggest that it's a very worthwhile exercise to read the clean version and take a fresh run at it as if this is a newly implemented thing, because you may find that it comes across quite differently to the disclosure pilot as it was originally implemented. And the changes are quite extensive in places, to the extent that looking at the red line version, it's quite hard to make sense of what it's saying. Now, the changes, according to the announcement, there was to be a reconvening of the Civil Procedure Rules Committee last month, and the changes would then be approved if everyone on the committee was in agreement. However, as far as I am aware, that meeting has not happened. And the other thing, which is unclear from the announcement, is when exactly these changes will come into effect, whether it would be immediately or whether it would take some time. All I can say about that, I suppose, is that with the April 2021 changes, they were originally promulgated some time before it came into effect so people could get ready for it. That said, the pilot itself did come into effect on the stroke of midnight without transitional provisions. So there's some uncertainty about this. The general expectation is that it will be sometime this autumn or by the end of this year that these further changes will come into effect. And the expectation is also that the version that you see on the announcement website will be the changes. There might be some tweaks, but the overall expectation is that it's going to be in the form that you find there. In terms of what you're supposed to do now, being aware of these changes, but then not yet having any formal status, the announcement offers an encouragement that users should consider the purpose and effect of the new round of changes. And if the parties are in agreement, there's no reason why they can't ask the court to apply the new version of the pilot in their particular case. But there's no suggestion that there's anything more compulsory than that anybody's going to be sanctioned if they don't engage with that process. One further word in passing on the extension, that will mean we'll have had 4 years of what was originally a 2-year living pilot. For my money, I think that the pilot or some version of it is here to stay, and it's hard to imagine us going back to Part 31 or something like it. But we will just have to see. Because it is a living pilot, there may well be further rounds of amendments to come and further extensions. Okay, now going into the areas of change. Multi-party cases was the first one of them, and here there isn't actually a great deal of change, but the pilot expressly acknowledges that multi-party cases raise difficulties for carrying out the disclosure pilot. So the particular issues that can tend to arise, and the pilot does specifically acknowledge these ones, is when you're doing your list of issues for disclosure, that can become a bit of a nightmare. The pilot doesn't say that, I'm saying that. It can become a bit of a nightmare if you have a claimant, 2 or 3 defendants, and each of the defendants joins an additional party, and then you have a chain of parties. What are you supposed to do? Are you supposed to have one list of issues for disclosure for everybody, or to try and carve it out in a different way? And also production of documents. Are you supposed to give the documents to everybody? Is everybody supposed to look at them? Or what about a party who's got no interest in the issues between you and one of the other parties? So what the pilot now will say about that is that multi-party cases may need a bespoke approach, and it tells the parties to talk about that, try to agree something, and to apply early. If you need disclosure guidance about it, do so. If you want to put forward a bespoke timetable for getting ready, do that. And if you want to put forward a bespoke approach, so for example, having just lists of issues for disclosures between parties or groups of parties, you can consider doing that as well. In terms of what I grouped together before as some miscellaneous changes around initial disclosure, etc., I just wanted to make a few brief comments about general approach, because the changes to the pilot introduce a few new pieces of terminology, which I think we'll need to be aware of. So Whereas, as I was saying before, the Chancellor emphasised that this is all about being reasonable and proportionate. That's what drives the pilot versus Part 31. In the amendments that are currently being proposed, there's an emphasis that the parties need to take a realistic approach to disclosure, in particular when they're thinking about the documents and sources of documents that there may be. So whether realistic is intended to be to introduce a new concept, if you like, to go alongside reasonable and proportionate remains to be seen. And also in another area, in paragraph 8.3, where you're talking about use of models for disclosure, the new changes say there's got to be moderation in the number of models in order to produce a practical disclosure process. And finally, perhaps in terms of general approach, this is the most striking thing about the changes. While there is a great burden on the parties to cooperate and try to agree where possible, there have been some more wording introduced to emphasize that the court will retain and will exercise control over the exercise, particularly if the parties can't agree about things. So there is definitely more room for the court to intervene, and the pilot emphasizes that that can be by disclosure guidance or by applications. I think that is all by way of encouraging the parties to be sensible about agreeing, or they might get a slap on the wrist from the court if the matter ends up having to be heard. In terms of those changes, these ones are, I think, generally speaking, miscellaneous, but I'll try and cover over them so you're aware of the ones that you need to notice. In terms of initial disclosure, you'll be aware that previously, though you didn't have to do any searches for initial disclosure, where you had done searches, you had to describe them in your initial disclosure list. The obligation to describe them has gone. I don't know exactly what lies behind that, but it may well be that it was perceived that having to describe your searches for initial disclosure possibly just gave rise to controversy in terms of what searches have been done or not. The issues for disclosure and the disclosure review document, this process has been significantly streamlined. So rather than the process whereby you try to agree your issues for disclosure and only after that did you then put forward your models for disclosure, that's been compressed down so that the claimant in the first place, who has the obligation to prepare the issues for disclosure, is supposed to prepare the proposed issues for disclosure and the proposed models for each party and do that in the first round. And then the other parties get 21 days to respond to that rather than 14. That I think is quite salutary because it brings forward what is probably the more controversial stage, is sorting out the models for disclosure. And it probably gives you a better prospect of being able to do all that preparation before you get to the CCMC. Model C, these points are really developments of what was already happening in the April 2021 changes. And what has gone is no longer described as request-led search-based disclosure. It is described now as disclosure of particular documents or narrow classes of documents. And there is express warning not to use this in a tactical or oppressive way, and express disapproval of using formulations such as any or all documents relating to a particular issue or matter. You do have to be precise and specific in order to show moderation and produce a practical solution to disclosure. Model D, the minor changes here, but this was around the concept of narrative documents, which certainly in my experience is often simply forgotten about and nothing said about it at the CCMC. So whereas before, if the court said nothing about it, the default was that you didn't disclose narrative documents. But the problem that creates is that you've then by default got to do all the work of deciding what are narrative documents and what are key documents and what should be disclosed. Now instead, if the court doesn't say anything about narrative documents, you should try to exclude them where it's reasonable and proportionate with a view to reducing the cost of review by the receiving party. So you're supposed to think about how much it's going to cost you to sift out the narrative documents versus how much it's going to cost the receiving party to review disclosure, including narrative documents, which you would otherwise sift out. That's a sensible development, but whether it opens the way to going back to the sort of paper bombing exercise that the disclosure pilot was supposed to remove, I think remains to be seen. Disclosure guidance, and then the last thing I'll talk about before I hand over to Lesley will be the less complex claims path. This has been quite significantly changed, and I think it's worth looking at paragraph 11 of the pilot as amended to see what this now looks like. So there's a move away from having to have a hearing So you can now seek disclosure guidance either at a hearing or on paper. And there's a further broadening of what you can seek guidance about and the circumstances in which you can seek it. So now it arises where there is you can seek guidance where there is a significant difference of approach, but where it's a point where guidance is required, but not a formal determination. This doesn't quite get rid of the issue that I think a lot of practitioners have, which is about deciding, well, when is guidance good enough and when do you actually need a formal determination? There's a further change in terms of the scope of disclosure guidance hearings if there is going to be one. So it's now provided they can be up to 60 minutes of hearing time and 30 minutes of reading, whereas before it was 30 plus 30. This, I suspect, is born of the experience that where disclosure guidance hearings have happened, they have often ended up taking longer than the originally provided and envisaged time. I've mentioned a couple of cases there which are worth having a look at to see how the court has actually been dealing with disclosure guidance when it comes up. So in the AH Pharmaceuticals case, that was one where the judge treated an application for disclosure effectively like it was a request for disclosure guidance, and he dealt with the application by saying, well, this is what I would have said if you'd come to me for a disclosure guidance hearing, so now go away and sort it out. In the data housewares case, the judge acknowledged that disclosure guidance just isn't going to cut it on some issues, and he rejected an argument that the party that applied for disclosure orders shouldn't have applied for that and should have come for disclosure guidance first. Now, whether he's swimming against the tide remains to be seen, because there certainly is a drive to use the process if you can. And last, but certainly not least, and I think this will be relevant to a lot of the cases that we at this seminar will deal with, there is a new path through the disclosure pilot for what are called less complex claims. And this has resulted in new appendices 5, 6, and 7, which set out effectively a modified version of the pilot and a new disclosure review document, a new set of explanatory notes. Without going into all of the detail of it, when you go through Appendix 5, you'll see how the process works and how you get yourself into the less complex claim scheme if that's going to be appropriate for your case. But the kind of cases that it's for, according to the new scheme, claims which by virtue of its nature, value, complexity, and the likely volume of extended disclosure may not benefit from the full procedure set out in the main body of PD 51U. Pausing there, I mean, that's quite subjective, and some of you may think that few cases benefit from the full bells and whistles, but you've got to focus on your choice being between the full bells and whistles of 51U or this reduced process. And importantly, it's said that if your case is worth less than £500,000, then it should be treated as a less complex claim unless the other factors indicate to the contrary. Now, clearly, value is not on its own a good indicator of complexity, and there are many sub £500,000 claims that are as complex as multi-million-pound cases. But this is the area where I think a lot of practitioners did feel that the disclosure pilot wasn't operating proportionately and effectively, was cases at the lower end of high court work. The new scheme does expressly invite parties also to think in this context about whether they might use the shorter trial scheme, which is a seminar in its own right. But certainly I think when getting ready for these new changes, it's probably also worth having a revisit of the shorter trial scheme to see whether or not your cases will fit in that as well. In short, the difference this makes, Model C and Model E go out the window. You can only have Models A, B, and D in the less complex claims system. The new disclosure review document is a lot shorter and simpler, at least on the face of it, because it's only got 5 questions rather than 12, but the substance is pretty similar. I think the idea is you still provide the same information, but you can do so much more briefly, and indeed if you do so at all. And issues for disclosure, there's additional guidance on this. Not only do you have to be focused about it and be sensible, but you should try not to have more than 5 if you can help it. Disclosure guidance is still available, and known adverse documents are still the same. So it's worth having a look at that scheme. I can see that being quite useful in some cases and hopefully promoting a bit more agreement before the CCMC. Right, I've gone through that at quite a clip, and I'm going to now hand back to Lesley, and if we have time at the end, we'll see if we can pick up some questions and answers.
Thanks very much, Ben. Ben, can you just take your screen share off? Thank you. Okay, everybody, that was really interesting, Ben, and I think really one to watch as to where we're going on disclosure. I want to move now to look at the new witness statement reforms. Now, this is, of course, a much more recent reform because it only came into effect insofar as it affected witness statements after the 6th of April 2021. So we've still had only a very short period of time with this reform. And I think that's probably reflected in the fact that, or reflects in the fact that there is still some uncertainty about the reform. Because of the time available, I'm going to make certain assumptions of you, I'm afraid. One is that you will broadly understand a bit about the history. I'm going to touch on the history of this because I think it's relevant when one is construing the reforms to understand what it was that was being sought to be achieved. But I am going to assume that you've actually read 57AC and the Statement of Best Practice. So unlike Ben, I don't have slides because really those slides would just have reproduced the provisions in 57AC, and I hope that's not necessary. What I do want to do is to stand back from the reform after a brief history in order to refocus on a couple of aspects of it, because I think it helps to understand what this is trying to achieve. So the first point to refocus on is that what the practice direction and statement of best practice are trying to drive back at is what would properly have constituted evidence in chief. And it's really significant, I think, to focus on that, because I think it's easier to understand what you can and can't do if you go back to that principle. One of the difficulties, I have to say, at the outset is that there isn't any definition in the practice directional guidance as to what that actually means. And for those of us who are, I'm afraid I'm probably the wrong side of this line, but anybody who is younger than me has probably never experienced evidence in chief. I only did a few examples of evidence in chief. And whilst judges sometimes order it in the modern regime, they don't, it's a rarity. So going back just briefly, therefore, so I'm going to touch on the history. I'm going to touch on the meaning of evidence in chief, and I'm then going to focus very much on documents, because it seems to me that it's in relation to adducing documents or dealing with documents in witness statements that people have had most difficulty. What the reform is not about has been made clear by a recent decision called the Mad Atelier, which is a great name that you probably won't forget. What that decision, it's a decision of Sir Michael Burton, sitting as a deputy judge at the High Court, is that the provisions are not about the admissibility of evidence. And I think that's again caused some difficulties for people. So, and to be honest, there's a whole separate discussion, I think, some of which I would encourage you was dealt with in a different seminar by involving Matthew Hall of King's Chambers, dealing particularly with the pilot for property cases. But there's a whole issue, it seems to me, that's been thrown up by the reform as to how you actually adduce documents into evidence. But anyway, back to the history. This was very much a judge-led reform. What happened was there was a strong sense that the judges, particularly of the commercial court, felt that factual witness statements were often ineffective in performing the core function of adducing the best evidence at proportionate cost. And briefly, what happened, and the reason I mention this still even now, is because these are documents that, to my mind, are still worth reading. So what happened was that the Commercial Court Users Committee back in March 2018 decided to grapple with this, set up a working group involving business and property court judges, barristers, solicitors, and members of the GC 100, who some of you who have listened to talks before from Ben and me will know that they were also very active in relation to the disclosure pilot reform. There was an online survey, there were the inevitable focus groups between October 2018 through to December 2018. There were 932 responses, which I think is probably quite high. And what emerged was that there was little or no enthusiasm for radical reform. Now, that might surprise some of you. I think, to be honest, it surprised me. But it's important, therefore, that you understand that this current reform is against a backdrop, therefore, of there being no appetite for wholesale sweeping reform. It's possible that that was informed by the experience of the disclosure pilot, because certainly by this time there had been some kickback, is probably the most neutral way to put it, in relation to the success of that from practitioners. So once you've rejected wholesale sweeping reform, you can see that the impetus then became to try to deal with some of the most heinous aspects of witness statement. I think it's fair to say that I don't think anybody was really arguing that the system was not broke. It was a question of the degree to which it was broken. There was then a final report, which was published in December 2019, and then an implementation report in July 2020, following various discussions with various subgroups. Now, it was perceived, therefore, that the particular problem, or the most heinous aspect of the problem, was that witness statements are intended to stand as evidence in chief. And so, arguably, and I know the same criticism has been made of the disclosure reform, arguably the tools were already there for the judges to deal with it. And one of the criticisms I've seen about all this reform is that if the judges had simply been stricter in relation to witness statements, then we probably didn't need the new practice direction. I'm not ultimately persuaded that that's right. I think it did need somebody to stand up and say it in a way that, so broadly, I'm declaring I ought to say I had nothing to do with the working group on any of this. I was on the working group, the disclosure working group. But broadly, I'm going to put myself in the camp of saying I accept there was a need for some reform, and that had to be done through a change rather than just the judges implementing. Some of the reforms are important, but I'm not going to deal with. So, for example, the fact that there is a sanctions regime which underpins this is something that is really important in practice, but is really boring for me to talk about. What I think you perhaps had been overlooked is that, as well as the CPR provisions in CPR 32, practice direction, CPR 3214, 3225, all of which informed the control of witness statement, is there were also business and property court guides. And again, I think I've seen the criticism said that really a lot of what the best practice is now seeking to achieve was possibly already in those guides. I think the difficulty with the guides is, whilst they were very good, there were different guides for each of the three main courts in the business and property courts. And they were important, but often simply overlooked. So the mischief that this was seeking to address, as I say, was the sense that witness statements had lost their main purpose of fulfilling the role of being evidence in chief. Again, perhaps I don't need to go over some of the problems, but briefly, what was the mischief? Well, the mischief was that there was a perception that witness statements were not always getting the best evidence out of witnesses. The polished versions that one saw at trial were often far removed from the witness's real testimony, and that was often exposed by cross-examiners at trial to great effect, and possibly in an unfair way. And I hold my hands up on that to say that's probably what I've done, is expose weaknesses in a way that possibly was a bit unfair to the witness. Witness statements was perceived as often containing what was called an aspirational version of events, which is an understatement if I ever have heard one. The problem of witness statements corrupting memory, again, it's a subject that I could talk about for a long time, because there's now been a lot of recent research just as to the inadequacy of memory, and in particular, the way in which memory can become corrupted. There was also, of course, the criticism, and this is, again, I don't think anybody could seriously suggest this wasn't the case, that there had been counterproductive over-lawyering of the witness statement to anticipate cross-examination, for example. And the process of cross-examination often was perceived to limit the ability of witnesses to make their own voices be heard. Now, I have spent a bit of time on that because, as I say, I do think it helps to understand what was being sought to achieve if you understand the problem that it was seeking to solve. I mentioned already that a more radical reform was rejected. But what I would say is a reading of the implementation report, the original working group, will inform your view as to what might happen if this practice direction doesn't succeed in changing practice. Now, so that's by way of history. What I want to go back to, therefore, is to remind everybody what evidence in chief was about. And it's much wider, I think, than people perhaps realised. You would struggle sometimes, however, to find a clear statement of this. And certainly there isn't one, to my mind, obviously in the CPR itself, which is where you might expect to see it. So what's evidence in chief about? Evidence in chief is firstly about giving evidence of primary facts. So those are the things that the witness has either done, seen, heard, witnessed, smelt, said, listened to, all those primary senses. And I should say that within the new practice directive 7AC, you will find that language reflected. If I was to carp a little on the drafting of the practice direction, you might say that you have to tease out these principles rather than them being fair, square, up front. But so firstly, evidence in chief is about primary facts as described. But it's always the case that you were also able to deal in witness statements or deal in evidence in chief with matters which go to the weight of the witness's evidence. So those are things that are slightly more nebulous. And again, you can tease them out of the new practice directive. The matters which affect weight are things like, did the witness have a good opportunity to observe the particular facts that they're giving, the primary fact that they're dealing with? Did they have reasons for their particular view or belief that they deal with in primary fact? And also, it is possible to deal in evidence in chief with other circumstances relating to the competency of the witness to speak to the matters that they give evidence about. Now, having reminded everybody, therefore, what evidence in chief is about in a way that I think could have been clearer in the current reform, to my mind, the difficulty comes when you look at documents. Now, if you read the practice direction carefully, I think you'd probably agree with me that what it's quite good at is telling us what we shouldn't do. And again, I don't propose to read it out, but there's quite a lot in there designed to address the very mischief that had been identified as part of the problem. So the reform is quite good at telling you what you shouldn't do. To my mind, it's perhaps less good at telling you what you should do, notwithstanding the fact that what is annexed to the practice direction is, of course, something called a statement of best practice. Now, my colleague Matthew Hall, when he gave the talk that I mentioned earlier, he said that this isn't really a statement of best practice because that would imply that it's something optional that you can just decide to follow or you don't follow, when in truth, we know that really we are being told that we have to follow it. That aside, the statement of best practice, therefore, becomes a really important guide to what we should be doing. But as I've already indicated, I think sometimes you have to tease out of the words and the language there exactly what it is that you have to do. It's particularly the case with documents. And I know from the chats I've picked up on and the other talks I've done on this, that how to deal with documents is something that caused real concern. Now, again, I think if you go back to the implementation report, you can get a lot of clues to what you're dealing with here. Plainly, what you shouldn't be doing is reciting or speaking to the documents. This is something that had crept in over recent years, I think. Bear in mind that the very concept of witness statements is a relatively recent one. And so it was only in 1986, which to my mind is recent, that witness statements, in fact, that became the norm. Now, but there's no question that what they had often become was a recitation of documents. And indeed, the worst ones, to my mind, were the ones that literally replicated what was said in the document, possibly sometimes even with little or no comment on them. If you were lucky, there was a bit of comment on them. But the problem often was that it was comment that the witness just wasn't competent to comment on. I've reminded you already of what evidence in chief can be about, but there were lots of things that had crept in that simply the witness wasn't competent to talk about. So the implementation report goes into the reasoning behind what it is you can, for example, show to the witness when you're taking a witness statement. Now, just let me pause, and I want to really simplify this down as far as I can. What is the problem with witnesses being shown documents when you are preparing their witness statement? Well, let's assume for these purposes, let's assume it's a minute of a meeting that the witness didn't attend, for example. It doesn't actually matter whether they did or didn't for these purposes. But let's assume it's a minute of a meeting. And the difficulty, if let's say it's several years ago, the difficulty of the witness being shown the document is that the document might corroborate their evidence or it might not corroborate their evidence. But either way, it's likely to add weight to their testimony. By that, I mean improper weight to their testimony, because they are likely to be influenced by the document rather than by their straightforward relying upon their recollection. And that, if I was to simplify all of these provisions down, is really the mischief that one is driving at, is that whether it would have helped you or not, the very fact of refreshing your memory by reference to a document can influence the proper weight that should be attributed to your recollection of it. I could speak again, and indeed I have spoken at other seminars, about the fact that the litigation landscape has, of course, completely changed because of the volume of documents. And I suppose what's happened with witness statements is that balance has been lost. It's become skewed between understanding what is properly in the witness statement and what should properly be left to be read by way of documents. But the gist of this problem, therefore, is that the reliability of a witness's evidence is affected if they are shown lots of documents. Certainly the documents that are unfamiliar to them contemporaneously with the events for which they're giving evidence. But even if they did have some contemporaneous recollection, one of the important parts of the reform that you will have read and seen about is the fact that therefore there has to be transparency as to the documents that the witnesses show. And that, I think, is good, because before this reform, just ask yourself this question: would the judge even have known whether that process that I've just described to you had gone on? And the answer is they wouldn't. Most witness statements didn't say, I've been shown this document and it reminds me that X, Y, Z. Often they just cut to the chase and just give the evidence, or say, or even worse, say something like, my recollection is assisted by this document. Well, actually that probably is true, but it's not really giving evidence at all then. So go back to basics. Remember the fundamental problem as to what this was sought to achieve as far as documents is concerned, and accept that the judge is at least better placed if the judge does know which documents the witness has been shown. And yes, I think there's the fear that people have expressed to me is, well, that might mean that the witness's evidence is somehow less good, less reliable. I'm afraid that may well be true, but equally, that is going to be matched by the cases where the purity of the witness's evidence is enhanced by the fact that they are properly transparent about what they have seen and not seen. So in the idea, what I think people are fearful of is the extent to which they should show documents to clients. Now, one question I have been asked is, and I think there's probably a distinction here to be drawn between your client and a third party witness. with your client, we mustn't lose sight of the fact that this reform doesn't alter the fact that your client probably will have seen documents in different contexts. So, for example, in the modern style of pleading, sometimes important documents are annexed to the pleading. Nothing in this reform is suggesting that your client has to sort of put out of their mind the fact that they've seen that document. Similarly, Ben's been talking this morning about disclosure. The same point arises, though your client will probably have seen documents in disclosure. And again, that has to be handled when it comes to taking your client's witness statement. But to my mind, nothing in the reform suggests that they have to just forget that they've seen documents. The real difficulty is third-party witnesses, where it had become customary to provide the witness with a little pack of documents and ask them to look at them, irrespective of whether they had any contemporaneous knowledge either of the documents themselves or even sometimes the events to which the documents were speaking. Now, with third parties, therefore, I think it's relatively easy that it isn't proper to prompt witnesses in that way. True, the practice direction or the best practice doesn't say that you can't do it, but you have to be transparent about it. And if a witness is going to be shown a document where they did not have any contemporaneous knowledge of it, the important thing that the reform makes clear is that you should only ask non-leading questions. And now, everywhere, of course, years of experience in learning to ask non-leading questions, but solicitors have been doing this for years. Solicitors have been properly eliciting the story without using leading questions. So again, I think it may just be a reminder to everybody that really the best evidence is obtained through non-leading questions. So for example, take again a simple example of this. Suppose that there has been a meeting which, and you're wanting to deal with that meeting in the witness statement. And let's suppose there is a document of the sort that I've described, but where the witness was not involved contemporaneously with it. It's really very easy. If the meeting itself is not an issue, then there is nothing wrong with you saying, we all know there was a meeting on such and such. So that's a leading question, but it's a leading question on something that's not an issue. Very different if the meeting is an issue, where you would have to step back and introduce a non-leading question. So around the lines of, can you remember what happened in July 2015, for example? Did anything happen in 2015? These are sort of open questions. Using my example of the meeting, if the meeting is not an issue, then you have to move to ask the sorts of questions. Well, what do you recollect about that? I don't think this is particularly difficult. I think that possibly if the implementation report and the report are to be believed, then there had been a blurring of the appropriate practice in relation to this. But to my mind, it is not as difficult as people think. Plainly, what you can't do, either with your client or anybody else, is put to a document to them where they had no involvement in the events or questions. So let's say, I think the example I often give is, suppose the other side produce a document that is not contemporaneous with the events, but is a subsequent document, so an email which purports to set out somebody's recollection of what happened at a particular meeting. That's the sort of thing you've got to be incredibly careful about, because you may be almost introducing for the first time the potential content of the witness's evidence in relation to that matter. So yes, you have to take care around the use of documents. Witnesses can be shown documents for refreshing memory. That's in the Statement of Best Practice at 2.6. but only for the purposes set out in the practice direction. And what's the downside to this? Well, to my mind, the best advice you can give is to embrace the transparency part of it and make sure that the witness explains clearly what it is they've been shown. You have to now produce a list of documents, and that, just to be clear, the list of documents will go wider than the probably narrower class of documents that the witness is actually likely to refer to in the witness statement. And that in itself is telling. Again, there was a bit of a fear that that might open up to the sort of cross-examination about those other documents. But I don't think we should over worry about that. You would be a very brave barrister, to my mind, to explore documents that the witness says that they have seen for the purpose of their witness statement, but which they haven't referred to in detail because they haven't got recollection independently of the document themselves. It would be very brave because you wouldn't know. It would be that classic territory into which cross-examiners don't tread, namely asking questions that you don't know the answer to, and possibly writing into the evidence matters that wouldn't otherwise be there. So what I think we've got to do then, I'm rapidly running out of time, so I'm going to pull it to a close. Go read the working group documents, because they do help you understand where we've where we've got to where we've got to. Do understand what evidence in chief is about, which, as I said, are primary facts and secondary facts. Do understand that you what you can and can't do, or by reference to the underlying mischief of witnesses being prompted by documents over which they had no contemporaneous knowledge or even involvement. But do embrace the transparency, because ultimately what that is sought to do is not to undermine your witnesses, the strength of your witness's case. Rather, on the contrary, it's meant to distill out the bits that can properly be given. As I say, I think there's a whole other debate to be had about how we now properly adduce evidence in the form of documents, whether that's done through deemed admissibility of authenticity and the admissibility of the evidence in trial bundles. I think has to await another seminar. But I am going to bring it to a close with that canter through some of the witness statements. Now, we've got 2 Q&As, which I'll try and briefly. So one is a question of protecting office holders. I think that's a disclosure question, Ben.
Yeah, so yeah, the question is in relation to office holders and disclosure, is there any case law that might assist in protecting the office holders when dealing with disclosure against the background of a lack of direct knowledge of the company's affairs? And I touched on this when I was talking about that case that said that you have to make reasonable and proportionate checks for known adverse documents. I don't know off the top of my head of a case that deals with that. I do have a couple of observations. I suppose one is that because of the scope of the disclosure pilot being by reference to Part 7 claims and some other types of claim, a lot of the litigation that office holders are going to be involved in isn't strictly speaking within the scope of the pilot. But to the extent that they are, or the extent that they want to follow that approach in dealing with disclosure, or I suppose that the extent they're concerned that the disclosure pilot will come to the kind of cases that they're doing generally, I think inevitably their position has to be taken into account, but the disclosure duties will still apply in terms of the inquiries they have to make. So if it is right, if that case is right, that you have to make reasonable and proportionate checks about known adverse documents, then something is going to have to be done, which may involve, yes, looking at obvious sources of known adverse documents, for example. Similarly, the office holder may have to make contact with former employees and with individuals within the organisation that would be expected to know about adverse documents. I suppose the twist in it for an office holder is that often the proposed defendant is going to be a former employee or the person who would know about the known adverse documents. And inevitably, the pilot's going to have to take that into account. So I think the short answer is the duties will apply, but they will take account of the fact that the office holder might well have a lack of direct knowledge and might not be able to ask the person who does have direct knowledge because they are the proposed defendant.
Yeah, I'm sure that's right, Ben. The second question raises a really tricky issue, which is, so the second question is relating to somebody, the position of a solicitor where a client who may have dementia and or capacity issues, but possibly not sufficiently bad to have to obviously appoint somebody else. And the question that we're being asked is, to what extent, or firstly, should an application to court be made? This is in relation to the departure from PD 57AC. The answer to that is undoubtedly yes. In other words, that in that situation, that is exactly where I would suggest an application to the court is required. And the question goes further and says, well, what should the solicitor put in the evidence? Well, there, it seems to me that the important thing is you make the application before you show any documents. And it seems to the witness, and it seems to me that the proper course would be to identify in the witness, in the evidence, the application, the concerns about the I'll call it the capacity issue, even though that it may be slightly wider than narrow capacity. I would identify the concerns about the capacity issue and identify the documents that it's desired to show to the witness, so that the court is appraised of the particular difficulty that arises in that context. Thank you. We've had some nice feedback on the chat, so thank you very much for that. Unless there are any other questions, I propose to bring it to an end, as we did say that we would try to finish reasonably promptly, and we've managed to do 8 minutes past 10. Is not too bad. Could I thank, first of all of you for joining us. At one point, we got up to 429 people, which is pretty amazing. Over 700 had signed up, so that's pretty good. Thank you, all of you who have joined. We hope it was useful. Thanks, Ben, for your erudition, is the word that's been used on the chat, which is very nice. So thank you, everybody. I look forward to perhaps seeing some of you in real life as soon as possible. But have a good day.
Thank you, everybody.